I'm Nate Eaton speaking today with Dave Leroy. He is the former Idaho Attorney General and who is still practicing law in Boise, right, Dave?
I am, Nate. How are you today?
Good. Thank you for chatting with me. I wanted to get your expertise in the fact that an issue that Larry Woodcock brought up the other day about JJ and Tylee's bodies still being they haven't been released to the family members for funeral proceedings. And that's created some comments online about people saying, why haven't the bodies been released? Why can't the judge release the bodies? And I'll just start with that question. Why do you think they still have the bodies in custody?
Well, the best practices for any kind of evidence, and certainly these bodies are the most significant of evidence in this set of cases. The best practice is to retain all of the evidence until all of the appeals and all of the appeals of the appeals have been completed, so that there would be no need ever, if a case were remanded for some kind of additional testing or some kind of new trial, to second guess what might have been, what could have been, what would have been. We do not know, as the trial looms larger, what kind of testimony there will be about what kind of scientific testing, what kind of certainty or speculation there will be about the respective cause of death of these two children, what the respective cause of death or the scientific findings might suggest about who might have done what to whom during what period of time to cause these deaths. So the short answer and the long answer is that until the trials are completed and all appeals satisfied, it's best practice to keep the evidence, in this case, sadly, the bodies of these two children.
Yeah. So we know early on, David, that autopsies were performed right after the bodies were recovered from the ground, and that was done by the state. They haven't made public if the defense have done their own autopsies, and that is the right to the defense to do their own. Am I right?
Yes, and you'll recall that they reserved the right. They specifically objected to any destructive testing or any conclusions that couldn't be retested. Although I think those issues have all been satisfied to this date. Once again, we don't know what will come up during the trial or on appeal as to this testing or these findings.
And what you were saying earlier, it sounds like, if the bodies were released today and suddenly the defense wants to do an autopsy in a month, well, that obviously is problematic.
Indeed, perfectly so.
I don't know if you followed the proceedings last week about the cameras in the courtroom. Both the defense and prosecution are asking that no cameras be allowed at future proceedings. Of course, the media were fighting that. What are your thoughts? I mean, this is such a high-profile case. Do you think that there is a complete camera ban, or do you think that there's a way to balance that?
Well, it's very atypical that both the prosecution and the defense agree on that particular issue. Obviously, the defendant has a right to a public trial. The prosecution, representing the public, has a right to expose to public scrutiny the findings and the testimony and the cross-examination, et cetera. But so also do the public and the media have a right to a public trial. So in this case, the two parties are kind of ganging up on the media and the public in a relatively atypical fashion. Often the defense wants no publicity or a limitation of publicity, but it's not very often that you find both parties in the criminal proceeding to hold that position. Thus, they've got the judge in a little bit of a box, but cameras in the courtroom are relatively unintrusive these days. It's not in the good old days where you had big Klieg lights in the corner and everybody was literally playing to the right-hand side of the courtroom so that their grandmother could see them in best light. These days, cameras are simply a function of what's going on in the corner and nobody's noticing, et cetera. On the other hand, I would expect that this is related to other questions, and the judge's decision will foreshadow other questions, such as, will the jury be sequestered during the trial? And if they are, and if the real question is the jury itself being influenced by some manipulation, regurgitation, adjustment of evidence presented in the media on the 6 o'clock news, then the jury can be kept away from that kind of publicity. It's a tricky question for the judge, an important one for the public and the media. But by the same token, typically in the federal courts, we don't have cameras in the courtroom now either. So it's not an earth-shaking decision in terms of anything but perhaps court TV, whether we can broadcast that live. And there will be a legitimate public viewing of some form or another, whether it's television in the courtroom corner, or whether it's a court artist drawing pictures of who's testifying today, and you reporting firsthand what you observed.
Yeah. You've been practicing law in Idaho for a while, for a long time. Have you seen a case like this, Dave?
There's no case like this. This horrendous set of allegations, the interrelationship of multiple death allegations, the overlay of religion and extreme views that are not related to any conventional religious view is utterly unique. I have said on some of the broadcasts that we have done together and on others that Idaho, once upon a time, a century ago, had an internationally significant, utterly unusual major trial where pretrial publicity and the judgment of jurors of a local nature in Ada County were tested. That was the Steunenberg assassination trial back in 1906, when an Idaho governor was blown up at his gate, allegedly by labor leaders out of Denver. And one of the lawyers who came to town was the most famous American trial lawyer, defense lawyer, Clarence Darrow, and he was opposed by William Borah and Governor Hawley, and it was celebrated all over the world because of the implications of the international labor movement being involved in retribution, killing of an ex-governor. In that case, Ada County was able to conduct what is now regarded and was then regarded as a controversial, but an honest and straightforward, objective trial. In fact, the jury decided that the labor leaders were not guilty, despite the testimony of the man who did the killing, the bombing at the gate, saying that they put him up to it. Nevertheless, that kind of glare of very unusual international publicity, literally in Ada County and Idaho, and probably in most jurisdictions, comes along only once a century. But this is this set of allegations, this very dreadful result for these two children and the grandparents and everybody else who's involved, is utterly unique in recent history, and you have to go back a century to find this kind of publicity and interest worldwide, in my opinion.
Yeah, and obviously with the internet, that has compounded it. I'll have to look up that case from 1906. I hadn't heard of that. I wasn't alive, so I'll have to do some research.
Well, there are some who allege I was.
Dave, thank you so much. Anything that you want to add?
No, it's always good to be with you, Nate. You've been not only the key that, in my opinion, broke this case, but you're staying on top of it. It's a pleasure to work with you.